We must be respected. We are majority. We are the people. We are the government. We are the army. We are the air force. We are the police. We are everything you can think of. We determine who can do mining in Zimbabwe. We determine who can construct a railway line in Zimbabwe. We determine who can build a road in Zimbabwe. No other party can do so.
Our citizens, especially those in urban areas, have endured poor service delivery for far too long under the opposition.
FreeTalk, me, your boy, Dara. Sefia Kasukwere's spokesperson Jacqueline Sunday is in trouble at the moment, with the Judicial Services Commission demanding that she withdraws some of the statements that she said about the bench. Now, in her statement, Sunday said that it looks like the judiciary has now taken the responsibility of choosing a president from the people, from the electorate. It is now deciding this on the bench. The Judicial Services Commission, among other statements that she said, felt like this was an attack on the bench, and she's a lawyer, and she has been asked to retract. Now, the law itself, in many people's views, has been seen as being abused or used to silence critics of those in government, that the executive is leaning heavily on the judiciary to silence critics and to retain power. This is what instructed Jacqueline Sunday's statements, which are now subject of debate. And as we do this debate, and as we have these conversations, Nelson Chamisa has challenged the results of the 23 and 24 August general elections presidency. His supporters are saying he should not approach the courts because the courts are not independent. Now, this is the public perception that is there. So for us to delve into this matter, to discuss these issues, we turn to those in the legal field. We turn to my guest this evening, Rosalind Hanzi, the director of the Zimbabwe Lawyers for Human Rights. We discuss the law the people, and power. On this, the Free Talk, with me, your host as usual, Dara B. Join me just after this break as we talk. Welcome back on this, the Free Talk, in proud partnership with the Frederick Newman Foundation for Freedom and Heart and Soul TV and Radio. Now, I am your host as usual, Dara B. And here this evening, I'm joined by Rosalind Hanzi. As we talk, we go legal. We discuss the V11s. We discuss the Constitutional Court. We discuss pre and post-electoral challenges. Madam Rosalind Hanzi, thank you very much for joining us on this, the Free Talk, in proud partnership with the Frederick Newman Foundation for Freedom. Now, you're the head of the Zimbabwe Lawyers for Human Rights, and you've been very much involved in litigation that has been around, that has been happening around these elections. Maybe let's start by just a small comparison: the 2018 general elections, pre-election period, and the 2023 general elections, pre-election period. Let us talk about the litigation around these two elections. Which one do you rate as more, legally compliant, if we're to say?
All right. Thank you, Blessed, and your team for inviting me to represent Zimbabwe Lawyers for Human Rights in this recording and session. And basically, maybe just to say that as Zimbabwe Lawyers for Human Rights, basically our mandate is to work towards fostering a culture of human rights in Zimbabwe. And because of the name that we have, Zimbabwe Lawyers for Human Rights, we do not choose which human rights to work on. And we have done work on civil, political, social, economic, cultural rights. And more recently, we are doing a lot of litigation around preservation of the environment, particularly preserving the wetlands. So coming to the question that you've just posed to me, I would want to say that if I look at 2023 and then I look at 2018 and even go back to 2013, there's a marked difference in terms of the pre-election litigation that we saw happening in Zimbabwe. Well, according to the election management body, the Zimbabwe Election Commission, they say that there was too much litigation that then led to delays in certain processes. So when we look at 2018, the litigation that we saw before the elections was the usual litigation that we had always seen around people challenging issues to do with the role of traditional chiefs in elections. We also saw litigation around access to the voters' roll, which has always been there even in 2013 and before. It has always been an issue where political parties and other stakeholders say we want access to the voters' roll. The other issues that came out were cases where there were allegations of intimidation of voters in 2018. And then there were also allegations of abuse of state resources by those who are in government, but were also participating in elections. And then there were issues around access to media by political parties. And one notable case that was taken up in 2018 that was not repeated before these elections that we've just passed was litigation against the president of the Chiefs Council because of the role of traditional leaders. It seemed to be something that was very prominent in that litigation. And then there were other issues, peripheral issues. But what is really different about 2023 is that we had more litigation around the nomination of candidates, which has never really happened, has happened in 2023. What I would say is when I reflect and also when I look at the legal environment when it comes to elections, there's a lot of work that needed to be done following the 2018 elections. There needed to be extensive amendments to the Electoral Act for the Electoral Act to comply with the Constitution. Why I say that is if we look at the 2013 Constitution, it is a chapter that is focusing on electoral systems and processes, which is Chapter 7. And it actually lays out how elections should be conducted. They should be free, they should be peaceful, what the Zimbabwe Election Commission should do, and what the other state organs and institutions should actually do to ensure that elections are held in a manner that could be deemed to be free and fair if there is compliance. But when I reflect back and also look back at the work that was done by other stakeholders, particularly civil society, there was a lot of advocacy to push the legislature to ensure that there were amendments to the Electoral Act for it to fully comply with Chapter 7 of the Constitution, and also to give effect to Section 67 of the Constitution, which is on political rights. Nomination of candidates came at a time when we have been having issues around monetary policies and changes. Today we are using the United States dollar. The next day we are using local currency called RTGS or whatever you want to call it. The next day you can go to bank your money and suddenly you realize that whatever RTGS that you are said to have is worth less than what you thought in terms of US dollars because of the different exchange rates that are always on the market. So when nomination court day came, which was on 21 June, the nomination fees had been pegged at a different rate from 2018. The presidential candidates had to deposit about 20,000 US dollars or its equivalent. And I think at one time there was belief that it had to be in US dollars, you know. And then, of course, there were also the members of parliament candidates who had to deposit a substantial amount, and then the local government candidates. But the main issue now was if you went to the nomination court on that day and maybe you had effected an electronic funds transfer, maybe the week before or on that day, you know, the exchange rate is always changing. As they say that there's the auction rate and then it determines what is the interbank rate. So what we then saw was that there were some candidates who actually went to the banking halls. They did the transfers on that day. Some had proof from the bank that they'd actually deposited in the relevant accounts. And then some had done electronically. You know, we're in the modern world now. And then you go to nomination court to file your papers. You believe they're in order. And then suddenly there's a challenge around the money not reflecting. So I strongly believe that more could have been done to avoid this litigation or these legal hurdles that then arose, leading to a lot of litigation around nomination. There were so many candidates who challenged the refusal of their nomination court papers when they went to actually lodge them, their nomination papers by the nomination court. And I would center that around maybe just generally compliance with the Constitution and also improving our electoral laws. Particularly if you look at the provisions on voter education and other related provisions that could have actually assisted in terms of increasing information on what is in the Electoral Act, what is required to be done by candidates. There's a very complicated process that some organizations that wanted to assist in terms of increasing awareness on electoral laws had to undergo around accreditation for voter education. Some of them were accredited late, and I still believe that if maybe the election management body had taken more time to also ensure that part of its role was to create more awareness on provisions of the Electoral Act, particularly around nomination, maybe some of these cases would have fallen by the wayside and they would never have arisen.
So some people argue that Zimbabwe has probably good laws on paper, but it's the implementation or the manner in which it is implemented that is problematic. As a lawyer, what is your view in terms of our laws and how they make it user-friendly to the people of Zimbabwe?
I would say it depends on which law you're looking at, basically. As I said when we started, I believe that the constitution that we had in 2013, on 22 May, was a better document I'm not saying it was a perfect document. And if we had followed through in terms of aligning laws with the Constitution, then we would have better laws. That would probably, if followed fully and not selectively, their laws of general application, then some of the issues and the challenges that we face as a country would not be there. So I would say generally our laws, especially the laws that are subordinate to the Constitution, are not fully compliant with the Constitution.
Is this deliberate?
Well, it really depends on how you want to look at it. If you look at developments from the last 2 years, then to some extent you can actually say it's deliberate, because this Constitution is a better document from what we had in 1980. It is an expansive Bill of Rights. It's not a perfect document, but it's better. It lays a foundation for certain institutions that are critical for a democracy to thrive, to reform, rebuild, and become more effective if the provisions are respected. So I'm going to maybe just go back to what we had in 2013. The three arms of government, we had the judiciary, the executive, and the legislature with certain powers which were limited by the Constitution. And then you see that the amendments to the Constitution, Amendment number 1 and Amendment number 2. And for me as a human rights lawyer, I would say my concern was around the implications of Amendment number 1 and number 2. Amendment number 1 basically changed the manner in which the leaders of the judiciary are appointed, the Chief Justice and the Deputy Chief Justice, and also the Judge President of the High Court. But also there are implications around their role when it comes to even election-related issues, because they are also responsible for overseeing the work of whether it's the other judges or the courts, when it comes to challenges to election results, or there are any election-related issues that arise in an election. For instance, you have the Chief Justice, who is supposed to be the one who oversees all the courts, but also is the head of the Constitutional Court. And the Constitutional Court is the one that sits to determine if there's a challenge to the election of the president. And then you see Amendment number 1 saying that the Chief Justice or the Deputy Chief Justice, who are supposed to be appointed through a public interview process, is no longer going to be appointed in such a manner, but will be appointed by the President in consultation with the Judicial Services Commission. So obviously that raises some concerns. Although some people would say, no, it's not necessary for you to take those key figures in the judiciary through public interview processes. But public interview processes, by their very nature, enable the ordinary person and even those who are in the field, the legal field or any other profession, to actually observe, appreciate, and also see that the appointments are merit-based of all the judges. So in this instance, you take away that appointment process. And then you have, of course, Amendment number 2, which led to extension of the retirement age, and then also promotion of judges from the High Court to the Superior Courts. So I would say if you want to have a thriving democracy, then you need to have three arms of government whose power is founded in the Constitution in such a way that they exercise checks and balances, and not one arm of government will be considered to be overbearing on the other.
Mm-hmm. So as you speak about this pre-election, there was a major challenge, Kasukuwere versus Loveday Mangwan.
Yes.
And Kasukuwere's spokesperson acting in a political capacity, but also she's a lawyer.
Yes.
She made statements that the judiciary had been captured, that the judiciary, the perception out there is that the judiciary is working with the executive. As a lawyer, let us talk about, as a human rights lawyer, let's talk about these incidences. How do they affect our democracy?
Well, I would say that My response is going to be grounded on our position as human rights lawyers and as an organization. For us, one of the key issues that we've always worked around has been that we want Zimbabwe to have strong institutions. We want the judiciary to be fully independent, and for us, we would have a fully independent judiciary that is well-resourced, where we have judges that have individual independence, in their own person. They are not influenced by others, even their peers. And then we also have institutional independence, where, the judiciary as an institution is fully independent from other arms of government. I would say when we have achieved that as a country, then that increases confidence. If you really reflect back on what's happening now, we have challenges in the economy. But if we made sure that the magistrates, the judges are well-resourced, their salaries are adequate enough, they have adequate benefits and other perks for them not to be influenced by anything. Do they have enough resources at the courts, whether it's equipment, whether it's manpower, for them to be able to effectively discharge their duties? So as a country, we really need to work around improving the conditions of service for our judiciary. And coming to the events that happened, I would say when some of these issues come out in the public domain, there also has to be an official response by those that are responsible for some of these institutions and arms of government to maybe clarify certain issues if there's anything that needs to be clarified, or to assure the public that the institution is still functioning according to its mandate in the Constitution. So I'm not going to have hazard to get into the incidents that happened with the judiciary, but to say for us, we always strive to say we need the judiciary to have institutional independence, adequate resources, financially, the courts running smoothly, everything that they need, whether it's libraries, computers. But we also want the judges to have individual, or the magistrates or prosecutors who are part of the judicial, or rather the justice system, to be well remunerated, to have the necessary benefits and allowances that would ensure that they just concentrate on delivering. And of course, there's need for capacity building. So I would say there are challenges around perceptions, which probably needs to be addressed by the Judicial Services Commission and the judiciary representatives, so that at least the public has confidence. But also there needs to be message discipline, particularly from the politicians. There's been some media articles that have circulated in the past where there are allegations that some political people have made statements around how they control all the institutions in the country, which is rather unfortunate because they should always remember that our Constitution is founded on the doctrine of separation of powers. And in instances where such utterances are made, I actually believe there should be action that should be taken by the other institutions to ensure that there is alignment of actions by some of the other actors with the Constitution. So once a political person, even if it's political banter or it's a campaign message, says something and it's not corrected or there's no action, they are not held accountable, then it can create a perception. So I believe more needs to be done in terms of communication.
So this failure to censor or to correct this, do you think it feeds into the perception that
it can feed into that perception? I believe that more needs to be done to ensure that if there are utterances that undermine, especially institutions that are critical to safeguard the provisions of the Constitution or the rights of the citizens, if there are any statements that are made, especially by other arms of government, that should be kept within the confines of the Constitution because of the checks and balances that should be there, then there should be some action that is taken.
You spoke about resourcing and empowering judges. So one would argue that this 400,000 $500,000 US dollar loans that were given to judges is exactly in line with your view to empower them to make sure that they concentrate on delivery. What would you say?
Yes, so we need to look at the practice in the other countries and also see where, if there are good practices, what can we emulate. The benefits that judicial officers get, or any person in the justice sector gets, they should be provided in terms of the law. And if they are given, it should be done in compliance with the law. And I noticed that the Constitution does have some provisions around how judges should be remunerated. But I think we need to reflect more in terms of how we can have a law that fully addresses some of these issues to ensure that even if some of these benefits are provided, then no perception or misinterpretation can arise around when those benefits are received. But it needs to be laid down in the law in such a way that there is no possibility of any interference by the other arm of government, with particularly the judiciary. In other countries, they've laid down how judges will be remunerated in their laws, their acts of parliament. It's very clear. And I would say the ideal position is for the Judicial Services Commission to be the one that determines that, you know, because it is supposed to be the one that is basically overseeing appointment of judges, you know, promotions and stuff like that. And not have any members of the executive involved at all, so that there is no perception around what is the motive behind providing certain, whether it's benefits or whether it's certain incentives to the judiciary. So I would recommend that we have better laws so that we do not leave room for the creation of any perception around having another arm possibly influencing the other arm for monetary gain.
Is it stands?
Because fiscal independence of the judiciary is possibly one of the most critical. They should be able to determine their own budget as the judiciary and be able to receive it without any political players getting involved.
So as it stands, it does look like they are beneficiaries of someone's mercy.
I would say as it stands, we have not fully addressed that legal issue, and it can be improved. But also as it stands, we should stop amending the Constitution in such a way that there's a perception that is created that one arm of government wants to dominate the other arm of government. We need to ensure that the concept of separation of powers remains intact in the Constitution, and also in practice it is seen to be respected and observed. And I would say this, in the past we used to cry a lot around defiance of court orders. That was something that lawyers would always say, but there's some court orders that are not being respected. And now this issue that arose just before the elections, as you are saying, it's a perception within the public domain. So it has to be addressed properly so that that perception does not continue to linger in the mind of the ordinary person. There needs to be clear that one of the most critical arms, which is supposed to be there to protect them when you have executive excesses, for instance, is able to be fully functional. They've got all the resources, and they feel that they are fully in charge and fully independent. They don't depend on any other arm.
Amazing. So, as we were going into election, the opposition led by Bullish Chamisa spoke about how the law was now being used as a weapon to silence critics. As a lawyer, did you see this? Does this have any credence?
The challenge that we have when we look at developments over the last 3 years, but also even developments since 2013, is that we have a constitution that is progressive, although of course we've made amendments to it, that is now sort of like, eroding some of the gains that we have as a country. Most of the laws had to be aligned to the constitution. But what we see now is introduction of laws that are trying to amend and align the constitution with those laws, to erode some of the constitutional provisions. So the key laws of concern to human rights lawyers are laws that are impacting on civic space, restrictions on civic space, and we saw the introduction of the Private Voluntary Organizations Amendment Bill, which of course introduces executive control of not-for-profit organizations, which is basically unheard of in most of the democratic countries. And it gives excessive powers to the minister to even be able to come and take over an organization and run it after placing their own people within the directorate and even the board. And then you see introduction of amendments to the Criminal Code that are commonly referred to as the Patriotic Act, which provisions are said to be introduced to ensure that, as the Minister of Information said, you love your country as a Zimbabwean. But when you then read through these provisions, there are some key words or provisions that are not defined. What is the national interest and what is sovereignty? Then when you look at these provisions and you start reflecting back, where are these issues basically supposed to be grounded? International law talks about sovereignty. And then you look at Zimbabwe's obligation under international law to respect human rights, which basically they voluntarily agreed to. Then you start wondering, but why do you introduce laws that are vague? And why do you introduce laws in instances where some of the crimes are already provided? The Criminal Code already has a section on crimes against the state. There's treason, attempting to overthrow a government. And then you see these provisions being introduced where if you have a meeting with a suspected foreign agent, there can be a suspicion that you've discussed certain issues like sanctions, or you've discussed trade boycotts, or you've discussed military invasions. It can be a suspicion even if there's no evidence, and you can be arrested for that. And if you are arrested and there are some aggravating circumstances where you don't defend the country, then of course you can be sentenced to the death penalty, which is obviously against the Constitution, because in the Constitution you can only be sentenced to death in certain circumstances, not because you have spoken to someone or met someone. In circumstances where you have committed murder under certain under certain serious charges. And then you look at developments over the last year. We have got an opposition leader who was a member of parliament in the last parliament. Job Sikalawe has been in prison for more than 425 days now.
Pending trial.
He is facing different charges, and obviously he's going to go through different trials. Some he has gone through, they are still ongoing, some have not even started. If they've started, I haven't received an update yet. And then you also reflect, we have certain high-profile people who have been arrested and convicted, and some have appealed against those convictions. You have some, the freelance writer, Tsitsi Dangarebwa, who was convicted after protesting peacefully with another person. She's convicted, she appeals, it's overturned because of course she didn't commit the crime she was said to have committed. So that perception that the law is being used to silence political activists and those that hold dissenting voices then can actually find credence. especially where you see that the prosecution was more to persecute. When a conviction is overturned, or when someone is taken to the magistrate's court, they go through trial and then they are not found guilty, then you can actually see how the law is being abused. But also when you look at developments around how the law is being applied, is it being applied as a law of general application to everyone? That's what the Constitution says. It should be applied to everyone, irrespective of their political affiliation or their beliefs or their position in power. We had the incident around the death of one of the CCC members just before the elections. And of course, the eyewitnesses, if their own account, they claim that they were engaging in political activities peacefully, and the other political party then attacked. But then the police bring a statement which is saying something else. But the fact that we lost someone's life there, and then the charges that are applied against those that are arrested, and also the processes that follow. Then when you look at maybe when the opposition party members are arrested, maybe in circumstances that are almost similar, what charges are placed or made against them, and how the processes unfold, then depending on how that plays out, then a perception can actually be created, which is real in some instances, that the selective application of the law and that the law is being used. In a situation where high-profile people are arrested, it sends a message to those that are not known by anyone, you know, the ordinary person, that if this can happen to someone like Fazai Maheri, for instance, who is a lawyer with a lot of experience, they have convicted, and then they have to appeal, then what more for you? And if this can happen to someone for maybe saying that they called for a protest and they're at a certain level of a political party, and you are just an ordinary citizen, maybe who was going to participate, then you'll have second thoughts around doing some activities or asserting and demanding certain rights. So it's actually a strategy that has been used. And if you look, for instance, at the number of arrests, you can see that it has worked to some extent, because most people are now risk averse.
To what extent do you think that the law was used as a weapon to win this election?
The law being used as a weapon to win the election, I would rather say whether there was a conducive environment that was prevailing. Because if I say that the law was used to win, then I can actually be preempting possible legal challenges that will be possibly filed. Remember that there are certain timeframes within the Constitution and the Electoral Act to challenge the outcome of the results. So I'd rather say whether there was constitutionalism that was prevailing before the elections, and whether it created a conducive environment for elections where everyone would regard them as free and fair, and where everyone would think or would believe that they participated to the level that they would want to participate. And I'm going to restrict my response to the environment that prevailed before the elections, caused by introduction of certain laws, especially on the work of civil society organizations. That's where I would want us to focus on for now. If you look at the law that I mentioned, the Private Voluntary Organizations Amendment Bill, though it was not signed by 23 August, it severely undermined the operations of civil society organizations. This law was not passed, remember, before the elections. It was not signed by the president. It was before the president. That's what we were told. But because of the implications of that law, the operations of civil society organizations were subdued. Some, of course, wanted to be seen to be politically correct, so that once the law is passed, they file their papers, then they can be registered. And then for some, obviously, there was a lot of instability created by that law. So you find that civil society organizations that are key players during national processes like elections were not fully operational. And for some, it was because they were not provided with the necessary go-ahead from the election management body to continue with certain activities like voter education and any other work that they wanted to do. And now coming back to the question that you posed, I would say that if you look at the court challenges that were filed, you can see that there were some issues around compliance with the law as it is, even where we say that the law had to be aligned with the Constitution. I'll take examples around the litigation that we had to compel ZEC to release the voters' roll. The Electoral Act says that once the election date has been set through a proclamation, any voter registration that has to be done should be done within 2 days of that proclamation, and the voter registration closes for that election. And obviously, that proclamation is done 3 months before the elections. The assumption is that if it's done 3 months before the election, then the voters' roll closes within 2 days after the proclamation of the election date. Then within a reasonable time, at least that roll should be cleaned up, it should be inspected, and then it should be shared with political parties in good time. But we continued to see a lot of cases that were being filed. But also in terms of the Constitution, there's a provision that says that stakeholders in any election should be provided with adequate information and material for them to effectively participate. And voter registration processes are continuous, so there needs to be compliance with the laws, but also maybe more clarity to set clear deadlines to say if you're going to close registration for an election 2 days after proclamation, then by what reasonable date, which is already set in the law, should stakeholders have that final voters' roll for them to look at and be able to prepare. And then we also have challenges that we saw around provision of the final list of polling stations. We wrote a letter to the election management body to say, can you please confirm or verify in terms of the final list of polling stations and where they are located, whether people who are living with disabilities can actually access them, all of them, or if there are any issues, but we never received a response. And then the other critical issue that then came out, where I would have a problem saying that the law was used to win, but I would rather say the law was not being followed in certain aspects, was when it comes to provisions around access to information on the printing of ballot papers. A court application had to be filed for that notice to be placed in the national newspaper for political parties to have access to that information. And of course, there were so many issues around delimitation. So the problem that I see is the fact that at times, some of our institutions and some of the key players within government especially are not complying with the laws for various reasons. And I would classify that is either non-compliance, selective compliance sometimes. And this really affects the culture of constitutionalism, where they should be actually respecting and defending the provisions of the Constitution and all the laws. And this affects how we are ranked as a country, not even by others, but even by ourselves, how we rank each other in terms of the rule of law. Is everyone subject to the same laws? Are they following the same laws? Or are they opting to rule by law where certain laws are introduced to manage certain players within the country to follow a certain position that is desirable by those in power?
So the SADC preliminary report spoke about the law being used to exclude other people. In the main Man-in-Chief Xavier Kasukwere was excluded from the ballot after nomination court had accepted his papers. And this, many believe, people on the street believe that this was done to save the ZANU-PF presidency.
I would say the main issue is we need to reflect on what the Electoral Act says about removal of a name from the voters' roll and whether that procedure was followed and whether the Zimbabwe Election Commission actually proved that they followed that procedure in the courts. Because before a name is removed, there's a certain process and procedure that has to be followed, including a notice that should be issued. So it's not just a random process where someone, but of course there's also the provision that says you should be resident for a certain number of months in the country. But
who
there's
is
a
counting?
process. Yeah, that is the issue now, and whether the provisions in the Electoral Act were followed around how a name is removed from the voters' roll, and whether that name was actually not in the voters' roll. That is what even the ordinary person can
the fact that
reflect on.
The fact that
make
nomination
their own
court,
assessment.
the fact that nomination court accepted that nomination means it was in the voters' roll, because you can't have your name accepted if it's not in the voters' roll. Is that not correct?
Well, in terms of the Electoral Act, you should be registered as a voter, and the people nominating you should be registered as voters. But of course, for me to go deeper into this case, I think I may actually be found in contempt of court. What I would say actually is to encourage the aggrieved parties, if there are still any aggrieved parties in this case, if they feel that possibly there were some issues that could have been addressed differently, to consider taking their case to another forum and their options. So once you exhaust local remedies, which appears to have been done, unless if they feel there are other local remedies, then they can go to the regional mechanisms, like the African Commission on Human and People's Rights. Zimbabwe has ratified the African Charter on Human and People's Rights, and it provides the mandate of the Commission. The mandate of the African Commission on Human and People's Rights includes receiving complaints against the states that are party to the African Charter on Human and People's Rights. The African Charter on Human and People's Rights provides for obligations of the state, including Zimbabwe, which is a member of the African Union, around certain rights that the citizens of that country have. And there is the right to participate in the government of the country, which finds expression in the right to vote or to be voted into office. So if they feel that they've exhausted local remedies, then there's a possibility of approaching such mechanisms.
Without falling foul to the Criminal Codification Act?
Well, basically, the real issue with the Criminal Law Codification and Reform Act is that the way that those amendments were introduced, a critical analysis would show that there was an attempt to evade obligations under international law, which the country has voluntarily accepted. Because if you look at international law now, sovereignty is not absolute. This concept of sovereignty being absolute was way before the Universal Declaration of Human Rights came into force and the human rights instruments were introduced. The human rights instruments limit what states can do on their citizens. And basically, human rights instruments were introduced to make sure that citizens are protected from executive excesses and state excesses. Human rights instruments started to be introduced after events in Europe around the Holocaust, because there was a realization that if states are left to do what they want with their citizens, then it can be disastrous. There can be very serious crimes that are committed. And
you hide behind sovereignty.
And you hide behind sovereignty. So as a lawyer who has been who has been keenly following developments in international law and human rights law, I would say that I believe that cooperation with mechanisms that are set with the African Commission, whether it's the mechanism to receive complaints and communications, due to the fact that Zimbabwe is a member of the African Union, or mechanisms that are set by the United Nations to receive complaints on human rights, cannot be considered to be criminal, because Zimbabwe is voluntarily agreed to be bound by provisions of human rights instruments. And there are also other instruments and other procedures that have actually been developed by some of those, like the United Nations, where they say that if you're cooperating with the United Nations, then you should not face any reprisals. And the African Commission is similar processes around cooperation and reprisals and how they deal with that.
But our law doesn't look at those things and give waiver in that.
Well, it's unfortunate that it doesn't do that. I would also want to highlight that that law now, the constitutionality is before the courts, where after a thorough analysis of whether some of the provisions that were introduced are constitutional, particularly whether they are in line with human rights obligations of Zimbabwe, an application had to be filed. I gave an example on the death penalty, the right to life. How can you be killed for meeting someone when the Constitution says even if you meet someone, you cannot be killed? You can only be killed if you commit a certain crime in a certain way. And then they'd also introduced provisions around loss of citizenship if you're found guilty of willfully damaging the sovereignty. Or I noticed that the loss of citizenship was removed last minute when it was eventually gazetted into law. But the loss of residence is still there, which affects the right to family life. So even the soft rights that you would look at, not just the civil and political freedom of expression, freedom of speech, freedom of association, or freedom of assembly, there are also other rights there that are affected by some of these provisions. If you are found guilty, then your right to vote is taken away. But the Constitution doesn't say that your right to vote should be taken away in such circumstances. So that's the challenge that we have, that some of the laws that have been introduced are not in compliance with the Constitution. And also, if you look at the Constitution, it's actually giving effect to the obligations that Zimbabwe has under international human rights law. Because those Bill of Rights provisions, Zimbabwe did not invent those. We're actually domesticating obligations that we have under the United Nations human rights architecture, and also the African Union, which has also introduced several human rights instruments, where states then say we are going to domesticate for our citizens to enjoy.
Now, you speaking about going to other fora, the Zimbabwe Lawyers for Human Rights was at another fora presenting the human rights situation in Zimbabwe. And
Yes.
it was as an organization and as yourself directly attacked for attending this panel and presenting what you strongly believed to be facts. And part of those facts involved myself,
Yes.
having been arrested. How, let's just talk about that moment for you.
Well, I would say that it was not surprising, given that this has always been the modus operandi of state actors, particularly at such forums. The real challenge that we have is that we have people who purport to represent our interests, but when they go out there, they are not representing our interests. And as a nation, we need to take more action to hold them accountable, because we cannot have people who are purporting to represent our interests going to misrepresent facts at such forums. As you say, some of the cases that we spoke about, because as lawyers for human rights, we are lawyers. Anything that we present at such forums or any forum is evidence-based. It's based on the cases that we've done. how do we go and start to misrepresent and create, or start stage managing events in the country. And what is interesting actually to note is that during that forum, we noticed that some of the beneficiaries of our work who have been arrested in the past before they joined government were some of the ones that were very critical of our statements. So, of course, for us, that will never stop us from representing people. We stand on principle. We are not selective. If we believe that someone's rights have been violated and that they were acting in accordance with the Constitution and that they fall within a certain definition, they haven't used violence, then we will always take up those cases. I think you've seen our work where we've even represented war veterans a number of times. I think last year we represented about 39 who were protesting and arrested. And in 2017 we did the same. We also represented some ZANU-PF youth members who were arrested for booing the former First Lady. Some of those cases we never put in the public domain because we also need to consider other factors, particularly around the situation of some of those people at that time. So it's unfortunate that when some people look at us and they are not in trouble, they want to label us as lawyers for maybe a certain political party or lawyers pursuing a certain agenda. But what is quite surprising is that when some of them are in trouble, they are the ones that will always run back to us because they know that when we are doing our work, we do our work because we are committed to our mandate and we are very clear about our vision and our principles.
Don't you fear for your security? Because, I mean, your organization has been discussed at various platforms, including at rallies. And you are seen as a hand extending Western influence in Zimbabwe and supporting regime change agendas.
Well, generally, of course, we are always concerned about the safety and welfare of our lawyers. Our lawyers have been attacked in the past. We have had lawyers who have been arrested. Beatrice Mutetwa has been arrested in the past for doing her work. I've also been arrested for doing my work at one time with my clients. And then we also have had lawyers like Alec Mushadehama, Andrew Makoni, and others being arrested for doing their work. But what we know definitely is that our work has always spoken for itself. And of course, if there are any attacks against our members, as an organization, we speak out, whether it's an attack against staff members. And we have also received support from other law-based institutions within the region, the Southern Africa Development Community region, and also at the global level, which is the International Bar Association. So it would be very unfortunate if these attacks and this hate speech against an organization that is doing its work and fulfilling its mandate actually acted upon. But of course, it's something that we continue to be conscious about, and we'll continue to do our work and ensure that our position is known as an organization. And of course, we'll also continue to see how we can have the necessary solidarity and support that we need for us to be able to remain focused. And we appreciate the role of the media, especially media houses like HSTV, Heart and Soul TV, in terms of creating awareness and publicity. In this day and age of social media, we believe that it would be very regrettable if there are any attacks perpetrated against any of our staff or our lawyers, because that will create a very negative perception against whoever has been responsible for that attack, especially considering that the United Nations actually does recognize the role of lawyers. And it is clearly stated that state actors have an obligation to protect lawyers when they are doing their work, and that they should never be associated with the cause of their clients. So we'll continue to engage those that believe that we are not patriotic enough. We will continue to create awareness around our role, but as an organization, we stand by our mandate of championing and defending the Constitution and human rights without fear or favor, and regardless of political affiliation. I think you know very well that in 2015, we took up a case in one of the ZANU-PF strongholds in Mazowe, where former farm workers were being evicted in their hundreds. I think there were over 200 at one time, against the former First Lady. Then she was actually First Lady. And for someone to then label the organization to say we are lawyers for the opposition, and yet we assist people across political affiliations, it's rather regrettable. But it also shows that there's no appreciation of our work. Maybe they do not understand, and we need to create more awareness around what we do.
So earlier on you spoke about not wanting to delve into matters because this could affect litigation that might or might not come. But the general perception in the public domain is that going, for instance, to a constitutional court to challenge the presidency is just a mere waste of time, and it will legitimize a flawed process because of issues that are around the constitutional amendment number 2 that you spoke about that extended the term, and it was vigorously defended. And then there was these freebies. This in a country where the majority are poor, someone's getting a $500,000 US loan. In your view, does it make sense to approach courts where there are this perception?
Well, I'm not going to prescribe whether courts should be approached or not, but what I would want to say is that if you look at our constitution especially, I always find a constitutional provision to support what I'm saying, because the constitution is the highest law in the country. If you feel that your rights have been violated, then you should be able to approach the court to vindicate your rights. So I would say that if there are any people who participated in the elections and they strongly feel that their rights to Section 67 or any other provisions in the Constitution were not followed, then if they feel like approaching the courts, they should approach them. There's freedom of conscience, there's freedom of expression. So for me to comment on whether it's wise or not, I feel that I'll be violating those rights. They should be able to independently decide on their own. And whether there are these perceptions around some of the institutions that they want to approach, that decision is going to be made at an individual level. Maybe if it's going to be something that an individual is to make, or at an institutional level, if there is need to make it at that institutional level. But definitely, I think as a country, we need to move. We can have the debates around whether it's wise or not, but I think we also need to be tolerant of each other's choices. Because what I may see as wrong, someone may see as right. So I would say if they feel that, and if they really want to, then I'm not going to comment on whether they should go or not. But what I'm going to comment on is that, as I've been saying, that more needs to be done around defending the Constitution, but also ensuring that the institutions that are there are able to play their roles and mandates as provided in the Constitution fully.
But if you were a candidate, would you step into a court?
If I was a candidate?
Yeah, knowing fully well these factors around against you? Or
well, it would depend on what I want to achieve. That would guide my strategy. What do I really want to achieve? Depending on what I want to achieve, I may go or I may not go. But obviously, I'm not going to go into what someone would want to achieve. I would not want to preempt. Because they may decide not to go, or they may decide to go. Because whatever you want to achieve, maybe something that is in the long term or in the short term. That will then guide your decision. Because
So-
as I have already said, are you someone who wants to take maybe your right to a remedy to a certain level? Or you are going to be taking that challenge for certain reasons, or you're not sure of the objective of why you really want to take this up? There needs to be a lot of reflection, but also you should be able to choose lawyers of your choice, which is in the Constitution, who can represent you without being associated with your cause, but also who can give you advice on whether you should go to court or not. But in the end, it's the decision of the candidate. And if I was a candidate, unfortunately, in this lifetime, I don't see myself ever getting into politics. I think I'm more effective in my role of continuing to push for accountability, particularly when there are those in power who are not following the Constitution and the laws that they should be following. They are not respecting the rule of law, but they are ruling by law. So in this lifetime, I'll never think about being a candidate. If I was a candidate right now, I think I'll be having sleepless nights about should I go to court, should I not go to court. And yeah, that I'm sure can be a very interesting for some time, but for some it can be quite stressful. Because now you have the court of public opinion, which has already made a verdict for you around whether you should proceed or not. But maybe you have exercised your right to freedom of conscience and belief, and you believe that you should be taking a certain direction. But also, you know, you have a constituency that you wanted to represent. It's very difficult. But I want to reiterate our position as human rights lawyers and as an organization that for us, because we are lawyers naturally, we want the justice system or the justice sector to be fully functional. And it can only be fully functional if we have very good laws that are grounded in a strong constitution, also supported by administrative reforms and practices that ensure that justice is done in a way that even the ordinary person at the village level would be very confident that they are approaching an institution that has been set up by the Constitution to defend them and also to exercise checks and balances. So we'll continue to push for provision of adequate resources, whether it's capacity building, but also to ensure that our institutions are functional.
So in 2018, a presidential challenge was brought before the court, and the chief issue that rings up to this day is an issue around V11s.
Yes.
And what many people have sought to understand from that was that those who came to court didn't have V11s. Yet when the judge or the chief justice was saying that you should have applied to open the residue so that we go to the primary source, which are the V11s in the ballot boxes. I've spoken to lawyers and they've said it's next to impossible to be, according to the law that we have right now, to open those ballot boxes and get primary residues. Can we talk about that?
There was actually a challenge, I believe, in 2013 around opening the election residue. If you remember, if I recall well, it must be the Timber case, where there was an application to open the election residue. And the reasoning behind dismissing that application was that, once the ballot boxes are sealed and the election residue is packed away, if you open this residue, then you can end up opening residue for other candidates that are competing in other elections. Because remember, our elections are harmonized. There's the presidential, National Assembly, and then also local government. One of the issues that we have been pushing in terms of the reforms has been to improve our laws around that aspect, opening residue, and also even when residue or ballot papers should be destroyed. Because if you look now, what we have is that the petition for the president has to be filed within a certain number of days. And then the petitions to challenge results for National Assembly, members of parliament, is done within a certain number of days, which is 14 for the president, it's 7 days. And then there's a provision around when election residue should be destroyed. But also there's also a provision which sort of like makes it impossible for you to open those ballot boxes and get what you want. That framework has to be improved. Because sometimes that election residue can be an answer to some of the challenges that we have had in the successive elections, but also it can build confidence in terms of how the election management body has run the elections, whether they've done it properly and whether the election residue is corresponding to the results that are announced. If you recall well, in 2018 we had a very interesting situation where the election residue was there, the V11s were completed, and then suddenly the wrong candidate is announced as the winner. And then this is taken to court, and of course it was dismissed on technicalities. But ordinarily, in a democratic society, why not give powers to that election management body where there's a mistake that is made that is very obvious for them to reverse that mistake, like announcing the wrong candidate, where everyone has got, the information who has the most votes, but they cannot even reverse that at that polling station or wherever they're going to do that announcement. So some aspects of our Electoral Act, unfortunately, were not harmonized with the constitutional provisions around, electoral processes and systems, but also for them to ensure that political rights are fully realized and enjoyed in the country. We also have provisions around access to justice. How do you have access to justice when some of the information that you need is not accessible for you? You cannot open election residue.
So in the fact that you can't open, it's almost impossible to open election residue. Is it even then possible to challenge the presidential result when you know from the last time, even if you have your own V11s that you collected, you have them, but the court wants primary data which is contained in the residue, that is impossible to open?
Well, I'm not sure whether the issue of election residue is going to be an issue if at all a court application is filed. But what I want to draw your attention to, and maybe to the viewers who are going to watch this program, is that one of the issues that we've always had around election dispute resolution has been the fact that we do not have rules of court that are fully aligned with the Constitution. And there were certain amendments to the Electoral Act that were not made. But you also need to remember that an election is a process. And what you are focusing on is what happens on voting day only. But there are so many other issues that someone could consider when they are deciding whether to challenge or not. Because remember, we had the election on the 23rd and 24th because of certain challenges that then arose. But to me now, from 26 or from 25 when we stopped voting, the next electoral cycle has started. And if you look at the issues that need to be addressed or processes that need to be done for a successful election, you cannot just rely on what happens on voting day. There are so many other aspects that you need to look at. And these are guided not only by what is in the Electoral Act or the Constitution, but also by international standards. Zimbabwe ratified the African Charter on Democracy, Elections and Governance, which also gives guidance around what environment should prevail before an election, how you can conduct free and fair elections. The SADC principles and guidelines provide some guidance on that. And even the African Union has also developed guidelines on elections that guide what should be in the laws, what should be done. So for one to send whatever they would want to challenge on voting day only, they also need to look at elections broadly as a process, not an event. Because if you're looking at it as an event, then fine. It's just what happens on election day.
It's just V11.
It's just V11s, basically. And also whether someone could vote freely by secret ballot. But remember that that person was not staying in a vacuum. They were living in a community. What was happening in that community that could have influenced whether they could actually then freely and independently say that they asserted their right to vote by secret ballot. So elections have to be looked at as a process, and the analysis has to be broader.
Amazing. But maybe as we close, Rose, how far are we as Zimbabwe, in achieving a community where there is balance, where the law is seen as the last bulwark of defense for democracy, where people believe that they are equal in all aspects, as provided for by the Constitution that you hold in your hands right now, and that has so many times been brandished by our leaders. And even the coup of 2017 was justified by brandishing the Constitution. Is this a sword of evil?
Well, I would say that as a country and as a nation, we still have a lot of work to do. And basically, we start at the basic level around tolerance, just mere tolerance. We need to respect each other, that we are diverse and we are unique. We cannot all think alike. If we all thought alike, then this country would not be as vibrant as it is. We would have people, behaving in a certain way all the time, and possibly that would affect even development. So we need to start by respecting the fact that we are diverse and we should be tolerant of divergent views. And what we also need to do as a nation is to accept that we are not always right all the time. As an individual, you cannot be right all the time. No one can be right all the time. And that we should always be learning and unlearning certain negative practices. So if you look at the gains that we made in 2013 around a better constitution, as I said, it was not perfect, but much better. And developments that you see over the last 10 years. It's unfortunate that as a country, we have not progressed to the level that we should have. And as you say, the Constitution is always used to defend certain positions. But what I see is that when the Constitution is used
Or abused.
Or selectively implemented or ignored, is to further certain interests. We need to be pushing for a culture of constitutionalism where we all respect the Constitution. And that work should start even at the lowest level, at young ages. How do we start to promote a culture of constitutionalism, even at ECD level, before the child goes for grade 1? How do they know that there's a constitution and you're supposed to be behaving in a certain way? But also, how do we create a culture within those that are in power to respect the Constitution? It will take a long time. And I believe that as a country, we have a lot of work to do so that we fully respect our own laws and we don't create laws to protect a few individuals, but we create laws to protect the country and its people and to advance the country, to advance development. If we are going to create laws where rights can be taken, then the country will never be attractive for investment by any foreign investor, because they'll be worried that if they are going to move into a country where, for instance, property rights can just be taken, then they are going to lose their investment. There's no respect for certain rights. So we need to create a certain culture, and I believe we are a long way from that. But it's not impossible if there's political will from the top leadership and there's the necessary support that is provided by the citizens.
I want to thank you very much, Rose Hans, the director of the Zimbabwe Lawyers for Human Rights. Now, the political will, some say it's more than just political will and support, but it's the love for the people. It's the love, it's the desire to do the right thing that our political players should have, instead of the hunger and thirst for power. This is what could actually move our nation to better places, where people get into elections and are prepared to accept results, whether they win or lose, and not push themselves to abuse or use the law to further their entrenchment of power at the expense of the ordinary people. Now, this is the Free Talk, in proud partnership with the Frederick Newman Foundation for Freedom. We believe in a diversity of views. We believe that people of Zimbabwe should talk to each other, should find common ground, and that the law is not only a Bible on how we live our lives in harmony with each other, but it is a path that takes this nation to prosperity, because where there's law, there's order, and there can be opportunities to plan for the future. This is the Free Talk. Now, I was in conversation with Rosalind Hansi, the executive director for the Zimbabwe Lawyers for Human Rights. I have also been a beneficiary of the work that they have done. When I was arrested in Chitungwiza during a by-election for allegedly taking pictures without authority, that offense was ruled to be non-existent in the first place in the courts. And as a result, myself and Chengete Chidi were acquitted. We thank you for the work that you do. We continue doing what we're doing because we know we've got you. You've got our back.
You're most welcome, Blessed. And it's unfortunate that people who are doing their work continue to be arrested, is what happened with the election observers from the Zimbabwe Election Support and Election Review Center. But we remain available because we believe that everyone should be able to assert and demand their rights in the Constitution, including their right to practice a trade of their choice, as you were doing.
Did. Until next time, this is the Free Talk. I, your host as usual, Dara B. Thank you for joining me.